Chapter 10, Discipline Rules. First, warning, admonition or reprimand. Warning, admonition or reprimand. First, there may be occasions when a superior officer may find it necessary to criticize adversely his subordinate work or call for an explanation, bringing the defect to the notice and giving him an opportunity to explain. If the lapse is not serious enough, like negligence, carelessness, lack of thoughtness, etc., to justify the imposition of the formal punishment of censure, but called for some formal action such as the communication of a written warning, admonition, reprimand, it may be administered, and a copy of such warning, etc., should be kept in personal file of the subordinate. Second, writing warning. Written warning, written warning, admonition, or reprimand should not be administered or placed on record unless the authorities satisfy that there is a good and the sufficient reason to do so. Third, if in the reporting officer opinion, despite the warning, etc., the official concerned has not improved, he may make appropriate mention against the relevant column in the annual performance assessment report (APAR). This will constitute an adverse entry and required to be communicated. 4. Where a copy of the warning is also kept in the APAR dossier, it will be taken to constitute an adverse entry, and the officer concerned has the right to represent against the same. 5. Warning should not be issued as a result of regular disciplinary proceedings. If it is found that some blame attached to the official, then the penalty of the censure at least should be imposed. 6. Warning is not a punishment and cannot be equated to a formal censure. Order number 19. 7. Warning letter, warning, letter of caution, reprimands or advisory administered to the government servant do not amount to a penalty and therefore will not constitute a bar for consideration of such government servant for promotion. Order number 19A. Second, disciplinary proceeding. The procedure to be followed in disciplinary cases against government servant is laid down in detail in the CCA rule. First, penalty. The following are the penalty that may be imposed on a government servant. Minor penalty. First, censure. Second, withhold the promotion. Third, recovery from the pay of the whole or part of the pecuniary loss to the government caused by the official negligence or breach of order. Third, A. Reduction to a lower stage in the time scale of pay by one stage for the period not exceeding 3 years without cumulative effect and not adversely affect his pension. Fourth, withholding the future increment of pay. Major penalty. 5. Reduction to a lower stage in the time scale of pay other than 3rd A. 6. Reduction to a lower time scale of pay, grade, post or service for the period to be satisfied in the order of penalty. 6A. Order should also specify as to whether the period of reduction will have the effect of the postponing future increment, and if so, to what extent. 6th B. Whether the government servant will regain his original seniority in the higher grade or post. 7th, compulsory retirement. 8th, removal from service. 9, dismissal for service. Removal and dismissal are both are the different things. Second, inquiry mandatory. Inquiries laid down in the CCS CCA rule should be held in following cases. First, to impose any of the major penalty in respect of these charges which are not accepted, or second, in minor penalty proceeding after presentation if the proposed A, to withhold increment for a period exceeding 3 years, B, to withhold increment with cumulative effect for any period, C, to withhold increment which is likely to affect adversely the pension admissible to the official. 3, when the disciplinary authority decide that an inquiry should be held even though proceeding have been initiated for the imposition of minor penalty only. Rule number 14 under 2 and 14A 14(1)(a). Third, intimation of the department proceeding. Whenever a disciplinary case is submitted to the disciplinary authority, seeking the approval of the disciplinary authority for the intimation of departmental proceeding against a government servant. A draft of the article of charge, article in all respects, along with the imputation in the support and the list of witness and the documents should be submitted to the disciplinary authority for its consideration. Similarly, whenever a case is referred to the Central Vigilance Commission for the first stage advice, a draft of the article of charge, complete in all respects, as proposed by the ministry or department should be submitted to the CVC for its consideration. GID 52, rule number 14. Procedure, major penalty. 1. The charge official should be served with a charge sheet together with a statement of imputation of misconduct or misbehavior and a list of documents and witness by which each article or charge is proposed to be sustained. On receipt of the article of charge, the government servant shall be required to submit his written statement or defense, or whether to be heard in person within 15 days, which may be extended to further 15 days, a time up to maximum 45 days from the date of receipt of the article of charge. Note FAN dated 2/6/2017 and GID 53 below rule number 14. Second, inquiry is a must to consider charge refuted by him. It must be conducted by the disciplinary authority or an inquiry officer appointed by it. It should also appoint a presenting officer to the present of the charge. It may use the serving officer as inquiry officer and presenting officer. Third, the delinquent official has a right A, to inspect documents referred in the annexure to the charge sheet, B, the engage any other serving or retired government servant to assist him, C, to engage a legal practitioner if the presiding officer is a legal practitioner. In other case the disciplinary authority may permit such an engagement having regard to the circumstances of the case. Fourth, if at the inquiry of the government servant pleads guilty to any of the article of charge, the inquiry officer should record a finding of the guilt in respect of these articles and hold inquiry only in respect of the remaining, if any. 5. Government side has the first priority to present the case and produce the witness and evidence. 6. Delinquent official will be allowed to offer his defense, witness and evidence. 7. Witness of the both side may be examined, cross-examined and re-examine. 8. The defendant may examine himself as a witness in his own behalf if he so desire. If he has not done so, the inquiry officer may generally question him to enable him to properly explain the circumstances cited in the evidence against him. Based on the reference from an inquiry officer authority oblique seeking the issuance of the notification by the central government oblique competent authority under section 4 of the department inquiry enforcement and attendance of witness and production of the documents act 1972. The inquiry officer is empowered to exercise power of the civil code for enforcement of attendance of witness and production of the documents. GID 52 rule number 14. The inquiry officer shall strictly follow the procedure laid down in rule number 14 under 18. 14 sub 18. Before closing the inquiry, rule number 9 of CCS pension rule also stated that the department proceeding initiated against a government servant shall be continued and conducted by the same authority which commenced them. GID 24 rule number 14. 9. Defense may be in writing or oral. Oral defense will be recorded, got signed and the copy supplied to the presenting officer. 10. Thereafter, inquiry officer will hear argument of both sides of the or take written brief from both. Presenting officer brief will be taken first, copy thereof supplied to the defendant and his reply brief obtained thereafter. Once a regular hearing in the department proceeding is started, such hearing should, as far as practicable to, continue on day-to-day basis unless in the opinion of the inquiry officer for the reason to be recorded in writing an adjournment is avoidable in the interest of justice. GID 52 rule number 14. 11. Entire proceeding should be recorded in writing, every page to be signed by the respective witness, the defendant and the inquiry officer, the copy furnished to be defendant and the presenting officer. 12. If the delinquent officer does not attend, ex parte inquiry may be conducted, observing the procedure in full. 13. On completion, the inquiry officer will submit his report and his finding on each article of the charge to the disciplinary authority. 14. The report of the inquiry officer should be submitted within the 6 months from the date of receipt the order of his appointment as inquiry officer. He may seek extension of time by citing reason in writing and may be allowed in addition time for 6 months at a time. Noted dated 2/6/2017. 15. Disciplinary authority may accept or disagree recording reason of disagreement, record its own finding and make a final order. 16. If the disciplinary authority who initiated the case is competent to award only minor penalty and if the opinion that majority penalty is to be imposed, it should send an entire record on finding without recording any opinion with regard to the imposition of all penalty to the competent disciplinary authority which will record its finding and pass order as deemed fit. 17. The disciplinary authority should forward a copy of report of inquiry and authority together with the tentative reason for the disagreement, if any, with the finding of the government servant giving him 15 days time to make any representation or submission. 18. The representation, if any, submitted by the government servant should be considered before passing final order. Rule number 14, 15 and GIDs. 19. Along with the final order, the government servant should be supplied with first a copy of finding of each article of charge, a copy of advice if any given by the UPSC where the disciplinary authority has not accepted the advice, a brief statement of reason of such non-acceptance. Rule number 17. Disciplinary authority 20. Disciplinary authority should take final decision on the inquiry report within the 3 months. 21. All ministry departments should ensure all the major penalty proceeding against government servant under their control are completed and final order are passed by the concerned disciplinary authority within the 8 months from the date of delivery of charge sheet on the delinquent government official. पांचवा, प्रोसीजर माइनर पेनल्टी. एक, the government servant should be given a copy of the charge sheet with a statement of imputation of misconduct. Second, he should be given reasonable time and opportunity to submit his defense. 3. On receipt of the defense, the disciplinary authority may pass appropriate order or may hold an inquiry if any. First, it is the opinion that such inquiry is necessary. Second, the inquiry is mandatory to view the punishment proposed. The procedure of the inquiry will be as for major penalty, rule number 16. 6. When prescribed procedure need not be followed. Following are the special circumstances where the prescribed procedure for inquiry need not to be followed. First, where a penalty is due for conviction on a criminal charge, or second, where the disciplinary authorities satisfy reason should be recorded in writing that is not reasonable participable to hold an inquiry in a manner provided, or third, where the president is satisfied that the interest of the security of state, it should not expedient to hold an inquiry in the manner provided. In case under category first, the disciplinary authority has pursued the judgment of the criminal courts and take into account the gravity of the misconduct committed, its impact on the administration and other extenuating circumstances or redeeming feature. Once is conducted that the government servant's conduct is blameworthy and punishable, it may impose such penalty as it is a competent to do. The penalty should be neither be grossly excessive nor out of the proportion of the offence committed, or one not warned by the fact and circumstances of the case. Regarding category 2, detailed guidelines have been laid down. In this regard, inquiry should not be dispensed with lightly or arbitrarily or out of ulterior motive, or merely in order to avoid the holding of an inquiry of because the department case is weak and is therefore bound to fail. Further, it is constitutional obligation that the disciplinary authority should record in writing, preferably in order itself, the reason for its satisfaction that it was not reasonably practicable to hold the inquiry. The reason, though brief, should not be vague or not just a repetition of the language of the relevant rule. In both the cases, the government servant should be given an opportunity of making representation against the penalty proposed. GIDs below rule number 18. 7. If the delinquent government servant dies during the pendency of the disciplinary proceeding, the proceeding should be dropped. 8. Streamlining of the conduct of disciplinary proceeding to reduce delay. Condition number 4. The title to the land should be clear.